Stuart from Constructing Excellence, Cambridge and Oxford Corridor. We missed the first few minutes of the webinar with Sarah Western of Greene Greene and Lorna Carter and Edward Carolan a few weeks ago. So we join Sarah as she talks about the requirements for contractors under the JCT contract in relation to force majeure and what they need to consider. And Lorna will then pick up some points on the same issue, whether COVID is a force majeure issue still or now or ever was, and carry on the webinar from there. I hope you enjoy.
The JCT contract requires contractors to use best endeavours. So, for example, if you have a difficulty with the supply chain getting materials, it's not enough just to say, my usual suppliers having delays. You will be required to look elsewhere and see if there's anything you can do to try and manage those delays.
Okay. Lorna, did you have anything to add on that?
I think Sarah will be pleased to say I agree with everything she says, which is a good start. I suppose it's the general principle about whether COVID-19 is a force majeure clause, and then obviously the proof of what impact that has is a separate matter. And I think it's unlikely, I have to put my neck on the line here, that COVID can't be seen in principle to be a force majeure event. I think it would be surprising. It's something that's taken everybody by surprise. And sort of throughout, it's seen as a boilerplate clause in most construction contracts that there's a force majeure provision. They often refer to epidemics and pandemics, and I think it would be highly unlikely for not to be considered that kind of event. But then we come on to proving what impact that's had. So it's not just saying, hang on a second, we've had a pandemic here. We've got to actually demonstrate that there's been an issue. And I think Sarah's quite right. There's a difference between lockdown 1 and lockdown 2. No one knew what they were doing, frankly, in March. The builders merchants didn't. They all closed down, and it was a nightmare for everybody. And we were hanging on Boris's every word every night to find out what he was going to say that construction were doing. It was a worrying time for everyone. We are in a much different position now with lockdown 2. It was made quite clear right from the beginning what was happening with construction. So lessons had been learned. But I think that this will all depend, your contract, well, when your contract was entered into, because if your contract was entered into prior to March, then you've got, I think, a fair run at it to say that COVID's a force majeure. But post-March, well, don't tell me that you don't know that COVID exists post-March. So at that point, you've now got to deal with it and address the issues in the contract. You can't just think, oh, well, I'll be able to use that force majeure clause anymore, because it's not something that we haven't all heard about unless we've been living under a rock for the past 6, 7, 8 months.
Okay. Would I be right in thinking, and I don't know if this, I'm just listening to the two of you discussing, and the point that has come up a few times in other webinars I've attended has always been the fact that you have to have, no matter what happens, you have to demonstrate the effect. So is it right to suggest that perhaps the point about force majeure is, because I know sitting in a bar as well back in January or February, people were like, oh, well, it's force majeure, and that seemed to be the answer to all of the problems. Is the force majeure point more of a legal, lawyerly thing to discuss? And then the main point, if you were a contractor, for example, would be to have those records and make sure that you can demonstrate what the effect of the event was. Is that the key? I
think it is, because we as lawyers want to find something we can hang the hook on and say, this is what we're relying on in our contract. This is the reason. But there's no good having a reason without anything to back that up. We need the evidence to support that, and that's critical. So good written records and receipts and emails and everything like that we can demonstrate that we've had those difficulties, that we've gone out to people outside our usual supply chain to try and get those materials, and the efforts that we've gone to. We need that as lawyers. We can provide you with a legal argument, but working as a team, we need our clients to provide us with the evidence that they've actually suffered these losses. So it's teamwork, really.
Great. And so, Edward, what's the response been to it? If anybody, I mean, have you come across any situations where people have brought a formal application for an extension of time based on COVID? And have you seen any responses to those applications at all?
I think from my experience dealing with main contracts and subcontractors, it's been quite a mixed response. Some clients have been sympathetic to the delays, and I suppose ultimately it depends on what the financial consequences are of that. However, I did actually speak to a contractor very recently, and during the first lockdown, they closed their sites down. They're a refurbishment contractor, and they work very closely in those environments. They made the decision to close all their sites down to ensure safe working environment. This caused a delay to the completion. However, at the same time, that occurred, there was a concurrent delay, which was an employer delay, and which was a relevant event, and the employer was culpable for. During the discussions they were having it, and the employer was quite happy to take on the COVID delay as a force majeure delay and give an extension of time for that, because not only was it a relevant event under the contract, it was also a relevant matter, which gave rise to a potential loss and expense claim. So in those circumstances, you need clarity to understand all the delays, what the consequences are, and whether they have an impact on the contractor delay or the employer delay, and whether they're concurrent delays, which I'm not going to get to the details of what concurrency is, true concurrency, but whether they are concurrent to delays experienced caused by the employer or caused by the contractor. And ultimately, I think it will come down to money and whether loss expenses arises from those situations, or whether the employer's delays are having an impact on their financial model for the project. So if it's picking up on Lorna's point again, it's keeping robust records to understand what was the cause of delay, whether it's a critical delay, and what's the effect of those delays on the completion of the project.
Brilliant, thanks, Edward. And I think, yeah, it comes back to the same points, doesn't it? Lorna and Sarah, did you have anything to add on that sort of point at all? Nothing at the moment. Good. So looking at legal mechanisms, so again, this is a bit of a lawyerly question. What sort of legal mechanisms are there available to ensuring we get paid during lockdown? If we can start with Sarah, have you got thoughts on that?
Yeah, I mean, there's been some sort of recent legislative changes as a result of coronavirus, which have had quite an impact on contractors and everyone else in the chain's ability to get paid. Previously, one of the most effective mechanisms was threatening and presenting a winding up petition. And that's only appropriate to do where there's no dispute. But quite often I'll have clients phone me and they'd say, you know, we've put in our invoice, the other side aren't disputing it, but, you know, the same old excuses, checks in the post got delayed, all that sort of thing. And in those sorts of circumstances, presenting a winding up petition was a really effective tool to getting payment, because as long as the other side had any money, the chances are they would pay you, because otherwise the company would be wound up. But the government, as you may have heard, have recently made changes, effectively stopping the presentation of winding up petitions. A bit like how they've stopped landlords evicting tenants. I think the motives were really well intentioned, but I'm not sure how well it works in practice. So just to go into the legal bit a bit, they've said that you can't present a winding up petition against a company based on a statutory demand that was served between 1st of March 2020 and 31st December 2020. You also can't present a winding up petition between 1st of March 2020 and 31st December 2020 based on the company's inability to pay its debts, unless you have reasonable grounds for believing that COVID has not had a financial effect on the company, or the debt issues would have arisen anyway. And it's hard to envisage a company that hasn't been affected by COVID at all. I imagine just about every single company in the country can show that it's had some sort of impact on their financial situation. So the test seems to be a pretty low threshold. I should also add that currently they're saying up to the 31st December 2020. Obviously, the government may well extend that. And so, like I said, whilst it's well-intentioned, I think it can potentially have disastrous effects. I've got a few clients come to me at the moment where sums are admitted by the other party. They're just not paying, and there's extremely limited recourse we can do given these current restrictions. Like I said, it does also say, or where the debt issues would have arisen anyway. And there has been a case recently which has decided that if the debt was owed prior to coronavirus, then you can still present a winding up petition. So I've had a couple where we've been able to get around it that way. But otherwise we're left, cash flow is so key to the construction industry, probably more than any other industry. And we're now left with this gap where you'll have sums admitted and you potentially can't recover them.
And Lorna, have you got any thoughts following on from that?
Yeah, very, very similar, really. It's a frustrating position to be in for many clients. That it's the most draconian step in trying to recover monies from debtors, but also it's probably the most effective. And so to have that weapon taken out of your arsenal is quite a massive impact, and there will be a chunk of debtors who would have been debtors this year, last year, next year, whatever, and we would have used that tool very effectively. There isn't a prohibition upon actually serving a statutory demand. So you could still proceed to serve the statutory demand, but question whether that actually has any teeth anymore, because you might serve the statutory demand, but unless you fall within the exclusions that Sarah's explained, you can't take it any further. So we're left with our other tried and trusted routes for trying to recover claims or cover debts, and that's really adjudication, mediation, and proceeding with claims under the pre-action protocol for construction and engineering disputes. Of those, I mean, I still think that number one for the construction industry remains adjudication, and that's something I think we're going to touch on in a bit. But yes, taking the ability to serve someone with a statutory demand and issuing a winding up petition away has certainly impacted on the ability to recover debts which are truly debts.
And just very briefly, because I'm not familiar with it, and apologies if everybody else on the call is, what is a statutory demand in as a few words as possible?
Okay, in a nutshell, it's a formal document which states that a debt is owed by one party to another party. It requires the debt to be paid within 21 days of that demand being personally served if it's an individual, or at the registered office of a limited company, similar provisions for LLPs and the like. And if it's not paid or adequately secured for by proposals of payment within 21 days, there's an ability to apply to the court for either a winding up petition or a bankruptcy petition as is appropriate. So it's a formal document.
Great, thank you. And then we were chatting the other day in preparation for this on the RICS summary adjudication procedure. And Lorna and Sarah, I think you both had some thoughts on the different rules and uses of that. So Lorna, seeing as you were already talking, do you want to start with looking at that?
Yeah, I think Sarah's probably had more experience than I have of the RICS summary procedure, so I'll let Sarah deal with that. The ones that I've had most experience of within the COVID period, if we can call it that, are the homeowner adjudications, which seem to be picking up. There's always a certain measure of those. Within the Construction Act, residential occupiers, homeowners, are usually excluded from those provisions, but you can enter into a contract which allows for adjudication with private individuals in their home, notably the RICS homeowner form of building contract. And I've had a couple of those come through recently, and I've actually found them to be very effective. They're slightly frightening in that the 28-day period that you usually have under the normal adjudication, which is frightening enough in terms of time frame, is actually reduced to 21 days. So unless you're aware of that right from the outset, you can easily get tripped up. So you do have to move very, very quickly. But I think that concentrates the parties' minds very well. We've had two recent examples. One example was where there was an issue over brickwork, and we had an architect as the adjudicator, and that got addressed very, very quickly, very, very well, with a comparison of the mock-up brickwork panel and the actual bricks installed on site. And I have to say, the homeowner there was being somewhat unreasonable in terms of the standard and the quality of the work, and that got addressed very quickly and everyone was able to move on. So that worked very successfully. And then more recently, I've had one where my client was based in Spain, but he had a home in London and was served with adjudication proceedings fairly quickly. But in that case, the other side couldn't demonstrate that we'd actually signed up to the RICS homeowner contract. So we argued that there was no right to adjudicate under the Construction Act, and there was no contract which provided for it. And we were able to persuade another architect adjudicator that we were right on that. So that was a bit of a result. So within about 7 or 8 days of receiving the papers, the claim disappeared. So that's good if you're a homeowner, not so good if you're a contractor, but the rule to the contractor is make sure you get your contract in place, which provides for adjudication, really. So from my perspective, adjudication has been pretty successful and is a good route to pursue in the absence of a debt recovery mechanism under the statutory demand winding up route.
And Sarah?
Yeah, so I recently had experience of the RICS summary adjudication procedure, which is something they've introduced specifically as a result of coronavirus. So I'm sort of assuming most people on the call already know a bit about adjudication generally, but it's typically 28 days, can be extended by parties' consent to have your dispute resolved. And therefore, because it's much quicker than court proceedings, it's also much cheaper. Although if you've been a party to one, you may not feel that, but compared to court proceedings, it is. So the new scheme is intended for disputes worth less than £20,000, and it creates an even shorter procedure. So instead of 28 days, it's 14 days, and it limits the adjudicator's fees to £1,000 plus VAT, which is significant actually, because depending on the dispute, the adjudicator's fees alone can typically be anywhere between sort of 5,000, 10,000, even more. So if you've got an amount owing of 20,000 or less, you can see it's disproportionate to even pursue the matter. So on paper, it seems like a really, really great idea. And I had a client where it was perfect for, so we commenced the adjudication. The other side actually didn't respond, but then the adjudicator asked whether they had consented to the procedure. And the whole point of adjudication is, as long as the dispute's crystallised, it can be commenced by any party at any time. You don't need the other party's consent. Here, the adjudicator asked whether the other party had consented, and they hadn't. And he therefore ruled he didn't have jurisdiction and therefore resigned. Both I actually spoke to RICS about it, disagreed with this view because it's our view that it complies with the Construction Act and therefore the other party doesn't need to consent. The scheme that Lorna's just described for homeowners, that's because under the Construction Act, as she said, residential occupiers are excluded, whereas the summary procedure is not for residential occupiers, it's for anyone. So as a result of that adjudication decision, him resigning, it sort of again severely limited the impact of what could have been a fantastic scheme. Because if you need the other side to consent, the chances are they're not going to. And then based on his decision, you're then not going to be able to use it. So what has been created to try and help contractors get paid in difficult times, again, has sort of had its teeth removed a bit. That's not to say another adjudicator wouldn't have come to a different decision, but if some are of that view, then yeah, its impact has severely been curtailed.
Really interesting. I have an interesting point about the cost of adjudication as well, because as you say, adjudicators' fees alone. I know a few years ago, one of my friends who works in the city in a big law firm had worked out how much one adjudicator roughly was making a year out of adjudications, and it can be quite expensive to with certain adjudicators, I know. So that is
adjudicators, we have been known to withdraw from the adjudication and resubmit. because of the cost of that particular adjudicator. So yeah, it is a big consideration, and to offer you that carrot of limiting the adjudicator's fees, and it's a great idea to then have the impact that, or have the effect that Sarah's experienced is very disappointing.
So yeah, I mean, we've actually had to start it again without using that limited scheme, and therefore the client face uncapped costs, which again, for a claim less than £20,000, is incredibly frustrating.
Yeah, interesting. Let's move to a brief look at trials and mediation by Zoom and online mediations and those sorts of things. I don't know if I've not come to Edward for a little while, so just in case Edward's had any experiences, have you had any hearings or anything like that you've been involved with that have been virtual, Edward?
Not online, no, not virtually. I have had an adjudication during the COVID period, and that was done by the normal documented process. But and there was a potential meeting to be arranged, but it didn't happen in the end. But during the COVID period of time, that adjudication went swimmingly well, like it does often in adjudication. So,
and that was.
I don't think adjudication has been impacted at all by COVID.
Yeah, no, I know one of my other clients has had an adjudication where they did do it virtually, and yeah, or either they do it remotely without any need for interaction, and it all works smoothly. Lorna, have you had any experience at all of the online hearings and discussions at all?
Yeah, absolutely, we have. In fact, my colleagues in our Peterborough office dealt with a fairly lengthy arbitration. I think it was Zoom that they were using, whichever platform, but I'm pretty sure it was Zoom. And it was actually a very good experience for them, because it was an international arbitration. It wasn't a construction arbitration. It was about fertilizer, very glamorous. And I think there were parties involved in it from 10 different countries. So actually the ban, because I think this took place in about June time, so there's a ban on travel. So everyone thought, oh crikey, we're going to have to, throw the towel in on the trial, and it'll have to take place later. But then, it was mooted that Zoom, could do this virtually. We can do this trial by Zoom, and that's what happened. And in fact, it was very successful because you cut down on all that travel expense and so on. And my colleagues reported back that, what was particularly helpful is when they were instructing a barrister, if the submissions were being made, they would be able to contact the barrister by WhatsApp with a message saying, can you raise this point, or that point's not wrong, or not correct. And it was a very positive experience that they had with it. So certainly in terms of the arbitration trial, using sort of multi-jurisdictions, that was very effective. For me personally, I've got a mediation coming up, which is going to be held on Zoom, but making progress with actually putting that in place seems to be very, very slow. So there seems to be a bit of caution by the parties to actually engage in the mediation by Zoom, although the reports that I'm hearing is that Zoom mediations have been proved to be very popular and very successful.
Yeah, that was certainly the experience. There are a few people that I know who've been involved in them virtually, and they've said they've worked really well. And as you say, save the travel time, the cost, and all of that sort of stuff, particularly if it's with parties from another country. Sarah, have you had any experience of these at all?
Yeah, I had an injunctive hearing by Zoom with the court, which I was really surprised. It seemed to work really well, actually. And the particular client on that one was very forthright and liked to interrupt. So counsel and I just spoke to him in advance and told him the importance of the mute button, and it worked really well. Whereas I think in real life in court, we might have struggled to mute him so much, but so it definitely has its benefits. But yeah, and also, I don't know if it's pro or con, but it was an urgent injunctive hearing. So it took place whilst I was on holiday, which meant because it was done virtually, I was able to just log on from wherever I was in the country. Whereas normally, you have to travel to the court, and as Lorna says, you've got the cost and the hassle of the travel. So it's making things much cheaper. And yeah, I thought it worked surprisingly well. In terms of mediations, I've not had one yet. I've again got one coming up, but my colleague has. And he sort of said he thought they were sort of slightly less effective mediations. I think being there physically in the room can sometimes be a lot more conducive to settlement, whereas when things are done virtually, I think it's easier to say no. It's sort of the old saying about looking people in the whites of the eyes. Now, I'm looking at you right now, Stuart, I can see the whites of your eyes, but you know, psychologically, I think it's much easier to say no to someone virtually than it is in real life. So it'll be interesting to see how that develops, because I think certainly for the future, everything like this is going to have to be done virtually. So people are just going to have to become accustomed to it, and it'll be interesting to see how it develops.
Yeah, there certainly seems to have been mixed reactions. There are some people who refuse to entertain the idea of doing things virtually, and others who absolutely, like anything with technology, isn't it? Some people love it and jump on it straight away, and other people won't play the game at all. So moving on from that, what's our experience been of the impact of COVID and Brexit, particularly when it comes to issues around supply chain or office overheads and things like that? I guess, Edward, this is a particularly good one for you in terms of quantification and measurement of office overheads and preliminaries and things like that. How has that been approached?
We have actually heard of contractors and subcontractors struggling to get materials and supplies on their projects, which has caused delays. And equally, we had an experience with a contractor in London where it's a large infrastructure project, and the site accommodation had to be increased by 100% to accommodate a safe working environment for their business and their project. Obviously, that has caused a significant increase in the cost of the project. This is a project where there's hundreds of workers in site, and it's over many floors, this accommodation. So by doubling it, it's a significant cost. So in terms of how, in quantification and measurement of that, you'd be looking at what was allowed for initially in your tender, which then into the contract, and measuring against what your allowances are in the contract to what you're actually incurring the cost. Which one of the areas is in disruption is measured mile approach, is by looking at what you're allowed for over a duration, what you've actually put to change or disruptions cause, and quantifying it in that way. So what construction engineering is continuing, there's continuing rises in costs in disruption and delays, which I would suggest that could be brewing for future disputes coming up.
Yeah. Lorna, have you had any experience of supply chain issues and how they've been dealt with at all?
Yeah, I have actually. So some clients of mine, sort of large manufacturer, and they have various sort of groups of purchaser who purchase groups on behalf of a number of their own customers. And we've had issues there where they've simply said to my client that they're not going to abide by the payment terms anymore, because they're unable to do so because of the impact of COVID. And it was trying to work with those purchasing groups who acted for a number of clients and trying to find a solution that everybody could live with, rather than just say you're in breach of contract, we're going to make a claim and we're going to get court proceedings underway. There was very much a directive at that time, which was probably midsummer, that try and work together, try to avoid disputes, don't get yourself into that situation. And so that's what we tried to do, to try to work with the supply chain, to work with the customers to see if we could agree extended payment terms, but terms that worked for everybody. And that's what I found, maybe going off on a slight tangent, but I've actually found over the past few months, it's quite surprising that people seem to have taken some heed to that. And I'm experiencing, because I'm doing both project work and dispute work, I thought that we would be very much in a situation where it was all disputes and we wouldn't be looking at any development work and everyone would be fallen out by now and that tempers would be frayed, etc. But I'm personally not experiencing that. I'm finding that people are actually trying to work together, because we've also got this lovely Brexit looming as well. So we've got the two, COVID and Brexit to try and address. And I think people are conscious of that and have looked at what it's going to cost to go to court, what it's going to cost to do adjudication or whatever method, and actually look at alternative ways of trading and working together. So, and I'm finding that lots of project work is coming in, so people aren't put off getting projects off the ground. So I must admit, it's a slightly different position that I'm sitting in than I expected to be come November, all these months after the first lockdown. So I don't know whether Sarah and Edward have found the same.
Sarah, have you got any thoughts at all?
Yeah, sorry, just unmuting myself there. Again, I think most people have approached this in a sensible way. That's certainly been my experience. I mean, there's always a few exceptions. We're all experiencing this and the impacts of it. And most parties are well aware by now it's not in anyone's interest to get in dispute. It's costly and only the lawyers benefit. So if the parties can work together, it's going to be in their interest to do so. That's been my experience. And again, the same as Lorna says, I've been surprised. I think beginning sort of, when did this happen? March, I saw still quite a lot of disputes work, but all the non-contentious stuff did seem to tail off for me personally. And then September, suddenly everything seemed to be kicking off again, and getting a lot of new instructions through for new developments. And then, fortunately, like I said, because lockdown 2, the government's been much clearer from the start. I think people have adapted and they're realising, well, we're carrying on. This is clearly going to be with us a while. Yes, we have to be sensible, but we've got to carry on as best we can. And so hopefully, the construction industry is robust, and hopefully we'll sort of pull together as best we can and keep it going.
I also think that often in construction disputes, it's one party against the other party, where this is a neutral thing happening outside the party's controls, which is not causing the finger pointing to go on. Therefore, the parties are trying to work together to resolve the problem, and they're trying to resolve the issues in the best interest of the project. So in a strange sort of way, this is a separate outside issue that's happening that's not caused by one party or the other, which is maybe slightly different. That's why parties are being quite more sympathetic about the issue, as opposed to what traditionally might see in projects where they're delayed or there's a cost increase.
So just moving into you've mentioned that there are non-contentious and projects being put together still, which is positive. Lorna, if I can come to you first on what people need to consider if they're going into contract now or negotiating contracts at the moment, and both in terms of Brexit and in terms of COVID, is there anything that you're advising people to do?
Yeah, I think it's about balancing the risk really, and making sure that you've got adequate protection in the contract. You understand the risk that you're taking on, and that you price for it accordingly. I had a tender in on a project for a client probably about a month ago now, and the provisions in the contract were that they had to absorb responsibility for all of the impacts of COVID and all of the impacts of Brexit on this particular project. And it's just so wide-ranging and impossible to quantify. And Edward will probably be able to comment further on that. But how do you actually, as a contractor, put a price on that? It's very, very difficult. And I think that it's about having a conversation, if you're able, with the employer and working together about how best to balance and price those risks. Because if the employer wants the contractor to take on all of those risks of COVID, all of the risks of Brexit, then there's going to be an increase in the price, which is likely to put it outside the employer's budget. So is that really what the employer wants to receive? I doubt that. So it's about having a grown-up conversation about what we're going to do about the risks and how we're going to price and how we're going to balance those. It's the same that you would do in any time in looking at a contract. So it's situation normal to an extent. It's just two more factors to think about when you're coming to pricing a job or when you're coming to negotiating over the terms. So it is very important to look out for those trigger words and look at what you're being expected to take on in that contract, or what you as an employer are expecting the contractor to take on, and is that really reasonable given the size and nature of the project, because each project will vary. In some cases, small domestic projects, then it's probably maybe reasonable for a contractor to take more of the risk on because they're perhaps more savvy about what the risks are likely to be. But if you're a big player, you're a big contracting company or employer that does a lot of projects, and is it really realistic and reasonable to expect a small to medium sized company to absorb and take on and price those risks, perhaps not knowing that that's what they're doing? So I think it's just really about being aware, looking at the detail of the contract terms, looking at the contract that you're sending out to tender or you're tendering to, and understanding what the risks are and making sure that those are properly allocated and properly priced, and having a difficult conversation if necessary, because it's much easier to have that difficult conversation at the beginning of a contract when everyone's happy and clappy and nothing's gone wrong, rather than when everything's hit the fan and no one's happy anymore. So it is about trying to deal with those, having those difficult conversations head on.
Great, thank you. And Edward and Sarah, do you have anything to add to that side of things, the drafting and risk management?
I'd suggest that in the tender process, that contractors ought to be looking at how they manage those risks, whatever those risks are for the particular project. And each project has its own specific risks relating to the project themselves or in the current COVID situation. As I mentioned earlier, the contractor I spoke to about the project when he closed the site, it wasn't possible to manage the site in the conditions of COVID at the time, whereas other projects may well be because of the size and the distance between the workers. One of the things that we need to look at in that process, the Construction Leadership Council's site operating procedures and how they impact on the cost and time of the works. And they recommend that the COVID site, secure site is recommended, and that includes carrying out a risk assessment of the whole site, what the impacts are of working in that site, maintaining safe distances between workers, cleaning the hygiene regimes, and also regularly talking to the workers and the site operatives about the whole process of COVID and how to make them secure. All that process has time and ultimately a cost impact on it. I'd also add to that is that when we're preparing tenders, is to clearly set out what the tender is based upon, set out the tender assumptions and the clarifications, and ensure that the assumptions and clarifications are incorporated in the contract documents some way so they get passed through. I often see where a contract is tendered for some work and what they thought they tendered for is not actually what's in the contract. Contract hasn't walked through their tender assumptions or whatever the tender said so. Also in the program of the works, I often see contractors who prepare tender programs where a dependency they're relying upon another party providing isn't incorporated in the program. And they start the program as their works to carry on, but quite often they're waiting for information to be provided, and that should be incorporated in the program as well. So it's actually having an understandable, really clear and set out program of what the work consists of. So that's generally what I advise my clients to do in these situations.
Good stuff. Okay. Sarah, did you want to add anything on to the end of that at all? Or have we... I mean,
just sort of similar really in terms of, a contract is fundamentally risk allocation between the parties. And as I said at the start of this webinar, force majeure if it's not included in the contract, it doesn't exist. We all now know about coronavirus. So depending on how the party is going to allocate that risk, then I would recommend you get express wording actually dealing with it as a specific event. And if they're not, then, you know, as Lorna says, and Ed would say, that the parties need to allow for it as best they can within the contract programme and their price. And that's obviously going to have repercussions for the employer. I think my main concern is, particularly if we are going to head into another recession, is that, you know, contractors start pricing lower for works to get the works, and taking on more risk, which is going to have real repercussions later down the line. So highly recommend that if people aren't already, that they get their contracts reviewed before entering into them. I'm still surprised by the amount of even sophisticated clients who come to me who've entered into contracts without reviewing them or realizing exactly what they've accepted the risk for. So yeah, I'd highly recommend you get that reviewed and make sure it does say exactly what you expect it says in terms of that risk allocation. It's not enough to say, we know about coronavirus, we assumed we weren't taking on the risk. You need to make sure that is specifically set out in the contract, that the parties agree it.
Brilliant, thank you. Right, so I think I'm going to take some questions now from the audience. So there's a few questions already been put into the Q&A box. So if anyone has any questions that they want to add, do feel free to do so. But we'll run through the first few that are on there already. There's a nice one from Paul Hardy, I think, which is goes right back to the start when we were talking about how the how everything's been addressed. And Paul says, do you not feel this is a typical JCT response? The contractor pays up front and then waits a long time for resolution. Do you think that's typical of JCT? Do you think that's an issue that contractors face a lot? If perhaps we start with Sarah, do you want to comment on that?
Yeah, I mean, hopefully the parties can resolve the issues mutually between them. Like I said, my experience is that most parties do seem to be being sensible about this. I suppose it is the concern that the contractor has to upload the cost up front. What they should do is then submit those costs in their next interim application. I mean, they vary under the contract, but they're typically monthly. And then it's always the option to them that if that's disputed, that they can then adjudicate the dispute and have it decided relatively quickly. So yes, there may be an upfront cost, but hopefully can get it resolved relatively quickly within a couple of months if you did adjudicate it. And I appreciate there is a cost to that. But yes, in answer to the question, that is how it operates under the JCT.
Mm-hmm. Let's do another one, I think. David has asked on the cost of adjudication, and we talked about the cost of adjudicators, but David said, is the real cost of adjudication not in the adjudicator's fee, but perhaps in the legal costs and the cost of expert QSs? Because they're costly things, aren't they, Edward? And advice to prepare and pursue the case on behalf of each party. Is it the issue that just adjudication isn't cheap?
Yeah, I think that's a very fair summary. I mean, like I said, I appreciate no party to an adjudication will consider it's cheap, but it is compared to court proceedings. In terms of the costs of those, I mean, for example, it's not always going to be appropriate. So I spoke earlier about the summary adjudication procedure. It's limited to disputes less than 20,000, and it does also say for non-complicated or not particularly complicated disputes. And if the adjudicator considers them too complicated, then they can refuse to hear them under the scheme. The one I was doing was a typical smash and grab, no pay less dispute, in which case it's absolutely perfect because it's relatively simple and cheap for a lawyer to prepare. Plainly, if you've got a dispute, for example, relating to delay, which in my experience are always complicated and expensive, it wouldn't be appropriate. And yes, I think that is one of the main issues for the industry, that if you've got a complicated dispute, if there's not much actually in dispute, it's always going to be disproportionate to pursue. And the industry's tried to do what it can to resolve those issues, such as the adjudication scheme, but it's always going to be limited in terms of if you've got complicated issues. It's really hard to address those cheaply.
Also, what might help clients in adjudications is how they prepare their own information before the adjudication commences. In my experience, you often have situations arising during this adjudication where we're still looking for information to respond or reply. So it helps clients in the adjudication process to reduce their fees of having their case best prepared as they can with all the facts surrounding the events, and also prepare their own delay analysis the best they can through those facts, and also producing the evidence for the costs that might arise out of that. So quite often clients can help themselves by reducing the costs by preparing a lot of information very clearly as they can.
I think the point is, isn't it, that, you know, as a referring party, you can help to contain those costs by, as Edward said, managing it, by getting your case prepared as much as you possibly can. What's out of the party's control is how much time an adjudicator will then spend looking at it, sending out directions, asking for more information, allowing numerous submissions from everybody. And that's what can make the adjudication process that much more expensive. So yes, of course, legal fees, experts' fees are a big issue to consider. And I think the point that we were really alluding to earlier is that, generally speaking, what's outside our control is what happens once it goes to adjudication, what the adjudicator decides to do, how much time he or her decides to spend on the matter, and what directions they give in terms of the parties making further submissions. So I think that's the key thing. That's when it starts becoming outside your own office, outside your own control about the expenditure of that money. Great,
thank you. An interesting one, and this is quite specific, but from Mark Firth. Whilst Ed was talking about risk provisions and allocations within contracts, where in an unamended JCT contract does risk lie in terms of ground conditions, obstructions, contamination, dewatering, as that's quite often a grey area between parties until you're on site. Edward, he mentioned you, so shall we come to you first? Do you have any thoughts on how JCT approaches ground conditions?
Well, I often see situations arise where there's ground condition issues under contract, and I have a particular one at the moment where there's a ground condition issue. It's not a JCT contract, but it's about what you foresee at the time, what the contract documentation information provide, what's foreseeable at the time based on that information. And whilst the contract may have what it states in the JCT, it's actually quite dependent on the risks provided within the information, what you can foresee in the contract, based on that information.
And Lorna and Sarah, do you have any comments from a legal perspective on that?
Well, from our perspective, we don't really think it's sufficiently clear. So we tend to address that in what I'm sure loads of contractors will be delighted to see our schedules of amendments to the JCT contract. But that's one of the very reasons that these are produced, because just to get some clarity as to whether it is going to be the employer taking that on board, or whether the employer provides geotechnical information and expects the contractor to absorb that risk. So it then provides clarity. So, you know, one little shout out for having a schedule of amendments.
And Sarah, did you have any thoughts as well?
Yeah, similar. I mean, as Lorna says, sort of every schedule of amendments I've ever reviewed puts that risk firmly on the contractor's shoulders. I've never personally seen it specifically excluded, actually, although, you know, the parties are free to allocate risk as they like. So again, it's one of those conversations to have up front, and again, it's one of those things to best clarify in the contract so the parties know exactly where they stand at the beginning. The other thing that often accompanies those clauses are ones regarding surveys that the employer's already undertaken, and they usually say that the contractor can't rely on them. So it's one of those key things that's about the due diligence for the contractor, in that if they are taking on the risk for that, then either obtaining assignment of any surveys undertaking that they are seeking to rely on, or undertaking their own surveys. Or, like I said, I've not seen it personally, but whether the contractor can negotiate specifically that they've excluded that liability. There's no reason why it couldn't be done.
Okay. So just looking at a similar sort of contract drafting side of things, David's asked the question, is the panel seeing any particular contract drafting to reflect fears of a shortage of labour and skills if the workforce disappears back home to Europe post-Brexit? Lorna, have you experienced any of that at all?
The amendments that I've been dealing with in terms of Brexit have actually, interestingly, been concentrating on materials as the biggest issue. But I suspect that that David's right, that this is something that is going to be garnering more attention the closer we get to the date, because obviously this is a big concern. But as I say, as things stand currently, it's mainly been the movement of materials in and out and protecting the supply of those. So I don't know whether you found the same, Sarah?
Yeah, exactly that, actually. So yeah, we are now often including specific wording to deal with Brexit. I haven't personally seen any wording regarding shortage of supply and skills, but there are sort of catch-all type wording we're sometimes trying to exclude, but predominantly the focus has been on materials, getting them through the border. But yeah, it's an interesting point, actually, and one I hadn't sort of thought that much about, because everything does seem to be focused on the materials. I think the construction industry is relying on the English workforce. It's all going to be fine.
But I think even the government are actually advising, and there's lots of adverts on the radio about actually having the right paperwork in place to employ staff, whether they're based in the UK or not. So it's an advice for contractors and other contract organisations to make sure all their staff comply with whatever the regulations that are being put in place.
Good. Okay, finally, and I just want to return back to dispute resolution, because there's a question that I didn't pick up, and I think we've just got time to squeeze it in before we finish. And I bring Sarah Mason in just to close everything off. So David again has asked another question, and this is an interesting point, because I think it's something that often gets overlooked, and perhaps, I don't know, for whatever reason, but does the panel consider that early neutral evaluation, perhaps used in conjunction with mediation, has a useful role in construction disputes instead of adjudication and the relatively high cost of that? So, Lorna?
I think that's a good way of looking at things. It'll always depend on the nature of the dispute and the parties involved. But that it seems to me that is something that the parties would be sensible to consider.
Yeah. And Sarah, did you have any thoughts on that side of things?
Yeah, I mean, it's nearly always in the parties' interest to settle things amicably, and that's one way of trying to do it. Again, it's going to depend on the specific dispute, the parties, and the way they behave. Sometimes you can just tell by the parties' conduct they're too far opposed and not approaching things sensibly, that, you know, adjudication, which is a very quick process, might be more appropriate. But on the whole, if parties can resolve things amicably, whether either by neutral determination or mediation, that's probably going to be in the parties' interest to do so.
Yeah. And Edward, have you had any experience or any thoughts on different ways of resolving disputes?
I think just picking up on Sarah's point there, it will depend on the dispute itself. And we've got a current situation at the moment, and the parties are so far apart, there's no point in going to mediation on the particular dispute. And it's almost the decision by itself that it'll go to adjudication because they can't agree with themselves and let somebody else decide that. And that's quite often the case when parties the relationship's broken down or the communication's broken down.
Good stuff. Okay. I think that's it then. So I'm going to hand over to Sarah Mason, who I've never done this before, but I brought her in from the audience into the room, and it's all very technological and exciting. But hopefully, Sarah, everything's working for you. So if you want to just let people know what's going on next and do your
Absolutely. Thank you, Stuart, and hopefully you can all hear me. For those who don't know, I chair the Cambridge Oxford Corridor Constructing Excellence Club. So thank you, Stuart, for hosting so well this morning, and of course to Sarah Weston, Lorna Carter, and Edward Carolan for your very interesting seminar. We've welcomed today CE clubs from Oxford and Berkshire, which is quite new for us and something I hope we'll be able to do more of in future. And having listened to you all speak today, all I can say is thank goodness for the legal experts. I have to confess I'd never heard of force majeure at the beginning of the year and had to Google it. I'm still not sure I'm completely clear, but you know we'll continue and look to you for advice, I'm sure. And again, really interesting to hear your different experiences. But the message I was hearing loud and clear is just how important it is for us all to work together. Just a little update on what we've got coming up over the next few weeks. We're certainly not resting on our laurels before Christmas. On the 3rd of December, we have Professor Gibb and Dr. Jones of Loughborough University. They'll be sharing their findings of research they completed earlier this year on the impact of COVID and the construction industry. The 8th of December, we'll be holding another one of our virtual networking breakfasts, followed by our AGM. So I do hope you'll be able to join us for that. 9th of December, we have the Estates Director from AstraZeneca. He will be talking about the research and development estates plans, which I'm sure will be very interesting, particularly for those at the Cambridge end of the corridor. One event also yet to be announced, we have another gin tasting event on the 10th of December. Those that were involved last time round, I think, found it quite pleasurable, so we're really keen to run that one again. And those from the other CE sites, do keep an eye on your own websites for an update on various clubs' activities. Thanks once again to you all, and particularly for those attending today. Thank you. Goodbye.
Bye-bye.